So, good morning everyone. My name is Muhammad Ali Rezam Lukman, and this topic is about the new Civil Code of the Philippines, Sales. This is Chapter 4. Chapter 4, Article 1573. So, Article 1573, the provisions of the preceding article with respect to the sale of animals shall in like manner be applicable to the sale of other things. So, as stated in Article 1572, it provides for the rule with regards to the sale of two or more animals together. So in 1572, it is also applicable to the sale of other things. So generally, a defect in one should not affect the sale of the others. This is true whether the price was a lump sum or separate for each animal. So for there's an exception if it appears that the vendee would not have purchased the sound animal without a defective one. So this is presumed when a team, yoke, pair, or set is bought. So sale of two or more things together. The points considered in the preceding article apply also to the sale of the two, just like I mentioned, or more things where only one or more of them, but not all, have hidden defects. Article 1574. So there is no warranty against hidden defects of animals sold at fairs or at public auctions, or of livestock sold as condemned. The sale of animals at fairs or at public auctions or as condemned, this article is a limitation to the provisions of Article 1570. It is based on the assumption that the defects must have been clearly known to the buyer. Next, Article 1575. The sale of animals suffering from contagious diseases shall be void. A contract of sale of animals shall also be void if the use or service for which they are acquired has been stated in the contract and they are found to be unfit therefore. So the sale of animals suffering from contagious diseases shall be void. So of course, this is not allowed. This is also illegal, or because when someone buys a animal suffering from contagious disease, it might spread a disease just like the COVID or some other contagious diseases. And again, a contract of sale of animals shall also be void if the use of service for which they are acquired has been stated in the contract and they are found to be unfit therefore. So an example of that is a racing horse. So if someone sells a horse that is unfit for its use, then it is void. So when sale of animals are void, are void, the article declares the class of animals which cannot be the object of commerce, animals suffering from contagious diseases and those found unfit for the use or service stated, just like I explained earlier. So next is the Article 1576. Article 1576, if the hidden defect of animals, even in case a professional inspection has been made, should be of such a nature that expect knowledge is not sufficient to discover it, the defect shall be considered redhibitory. But if the veterinarian, through ignorance or bad faith, should fail to discover or disclose it, he shall be liable for damages. So, for the hidden defect of animals, uh, if the veterinarian, uh, through ignorance or bad faith, he will be liable for the damages if he fails to discover or disclose the defect of the animal. So before we proceed, what constitutes redhibitory defect of animals? So redhibitory defect is a defect in the article sold against which defect the seller is bound to warrant. So Article 1576 is another rule specially applicable to animals. To be considered redhibitory, the defect must not only be hidden, it must be of such nature that expert knowledge is not sufficient to discover it. So meaning there is no prior knowledge about it. However, if the veterinarian fail to discover it through his ignorance or fail to disclose it to the vendee through bad faith, he shall be liable for damages. So Article 1577, the redhibitory action based on the faults or defects of animals must be brought within 40 days from the date of their delivery to the vendee. This action can only be exercised with respect to faults and defects which are determined by law or by local customs. So limitations of action in sale of animals. The redhibitory action based on the faults of animals shall be barred unless brought within 40 days. So from the date of their delivery to the vendee. So additional, what should be considered redhibitory defects in the sale of animals are only those determined by law or by local customs. So if the defects are patent, there is no warranty against such defects, although there exists a redhibitory vice. So Article 1578. If the animal should die within 3 days after its purchase, the vendor shall be liable if the disease which caused the death existed at the time of the contract. So it is the responsibility of vendor where animal dies. If the animal sold is suffering from any disease at the time of the sale, again the vendor is liable should it die of said disease within 3 days from the date of the sale, not the date of the delivery. So if the death occurs after 3 days, he is not liable. So more than 3 days, the vendor is not liable. If the loss is caused by a fortuitous event or by the fault of the vendee, and the animal has vices, Article 1567 should be applied. So next is Article 1579. If the sale be rescinded, the animal shall be returned in the condition in which it was sold and delivered. So the vendee being answerable for any injury due to his negligence and not arising from redhibitory fault or defect. So you return what you get. So liability of buyer in case sale of animal is rescinded. So if the vendee avails himself of the remedies granted by the Article 1567, the vendee must return the animal in the condition in which it was sold and delivered. In case of injury due to his negligence, the vendee shall be responsible. So, but this would be no obstacle to the rescission of the contract due to the redhibitory defect or fault of the animal. Also under Article 1556, the buyer may not ask for rescission where he has created new encumbrances upon the thing sold. Next, Article 1580. In the sale of animals with redhibitory defects, the vendee shall also enjoy the right mentioned in Article 1167, but he must make use thereof within the same period which has been fixed for the exercise of the redhibitory action. So, the alternative remedies of vendee in sale of animals, the vendee has the same right to bring at his option either a redhibitory action or an action quanti minoris. So, the action must be brought within 40 days from the date of the delivery of the animals to the vendee. Next, Article 1581. So, the form of sale of large cattle shall be governed by special laws. So, form of sale of large cattle. So, the special law governing the sale of large cattle is Act number 4117, now found in sections 511 to 536 of the revised Administrative Code as amended, providing for the registration, branding, conveyance, and slaughter of large cattle. So the Administrative Code of 1987 has superseded the revised Administrative Code. So under the Presidential Decree number 533 or the Anti-Cattle Rustling Law of 1974, no person, partnership, association, corporation, or entity shall engage in the business of buy and sell of large cattle without first securing a permit for the said purpose from the provincial commander of the province where it shall conduct such business, and the city municipal treasurer of the place of residence of such person, partnership, association, corporation, or entity. The permit shall also be valid in such province. And also, the sale must appear in a public document. So I think that's all. So thank you for listening.